to see you. Always good to see you.
Yeah.
You ready for this one?
Sure.
All right.
You okay? Do we need to have a living trust to avoid probate court? First of all, for people who don't know, explain what that is just to begin with.
A living trust, really what we're talking about is called a revocable living trust, generally speaking. It's just an estate planning device. In all seriousness, it's what most people are thinking of when they say will.
A will. Mm-hmm.
Right.
Yeah, what they're really thinking of is a revocable living trust, because most of the time when people write a will, the idea is I'm going to direct where my assets go when I die, and I'm not going to have a probate judge look at it. But
That's what they think.
And that's not what a will does. We've talked about it lots of times on the show, and we're going to keep talking about it. Because we got to make sure everybody understands a will does not avoid probate. It just gives the probate judge instructions on how everything's going. Right.
And what can he do or she do in probate? What can that judge do?
Well, really, the judge is limited by what that will is going to say. So the judge is going to follow the directions unless some provision of the will is in conflict with law. Generally, what's going to happen in that scenario is the person who is harmed by that unlawful provision is going to bring their own action, and the probate judge is going to have to litigate it and figure it and sort it all out. So and the real hassle with that is it's incredibly expensive.
That's what I was going to ask
Even
you.
if you don't have a dispute, there's fees that are going to have to go to that probate court, the lawyers, to get that will probated.
If you don't have that and it goes to probate court, what can the probate judge do at that point?
At that point, the probate judge is going to follow Missouri's intestate succession law, because there's a law that says if you haven't said what's going to happen, this is what's going to happen with your stuff. Now, quite frankly, a majority of the people are probably pretty satisfied with that. It's going to go to your heirs. It's going to go to your spouse. If you're survived by your spouse, it's going to go to your kids. It's going to go to your parents. And it's just going to go kind of the way you would think it would go. So most people are generally happy with the intestate succession law, and that's why it was written. We want, nobody was trying to do anything
Make it easy.
goofy with it. Make it easy.
What if people show up when they found out you've passed, and they show up and they're like illegitimate children or something? What happens with that?
Well, it's going to depend if you've made an estate plan or you haven't made an estate plan. If you haven't
made
made one, then if they can prove they are who they say they are and they are an heir, then they would take, under Missouri's intestate succession statute, along with all the other heirs, their share, along with all the other heirs. Now, we have a question.
Yes, we do. I just wanted to go to the ground rules there.
We explained all that. So the issue here is, do we have to have a living trust to avoid probate? You don't have to. There are ways to avoid probate without having a revocable living trust. It really depends on your situation, the amount of your estate, and what you want to accomplish. You can use some non-probative tools under Missouri law, such as payable on death accounts, beneficiary deeds, transfer on death, titles for cars and things like that. That can accomplish a lot of things. Now, that's not going to necessarily accomplish everything, and you're not going to be able to do the things that sometimes people want to do with estate planning, which is really direct where all the assets go and maybe get a little bit creative with some of that. So a trust is actually going to let you do really whatever you want within the confines of the law, where the other tools that we have are really for people with smaller estates, maybe just a home, a little bit of an account. You get into some bigger assets, some greater amounts of money, you have to deal with tax planning issues. A trust is going to be better for that. The other place where revocable living trust can come in handy is when you're doing some end-of-life planning, like that nursing home issue, and you get into all those things, and if we're going to have to dissipate all of our assets, and we're going to lose all of our money in long-term care, sometimes a trust can be an important tool, not the end-all tool, but an important tool to helping avoid some of those issues as well.
So, I mean, best idea, of course, is to talk to an expert, talk to an attorney, that sort of thing, in order to be able to set these things up properly, because it's not obviously not a one-size-fits-all.
No, it's not at all for everybody. You need somebody to look at your individual situation and give you good advice on which one of these is the way to go.
So now, Will, do you need a will and a trust, or do you need...
Typically, what we're going to do when like we write these in our firm is we'll write the revocable living trust, but we're always going to include what's called a pour-over will, which basically says if I forgot to put anything in the trust, because you have to put the stuff in the trust, you have to title it in the name of the trust. If I forgot to put anything in the trust, here's what needs to happen with that stuff. It's just.
Can it be as simple as all of my assets are divided equally between all of my heirs?
It can be that simple in the document. What people need to understand, creating a will is not simple. You've got to use specific language. You've got to have it witnessed and notarized in a particular format. There's actually, they call it a ceremony sometimes.
Yes. Right.
It's not quite that formal, but there is a process you have to go through to make sure that everything is properly authenticated and that it is, in fact, just writing it down and signing it doesn't accomplish what most people think that it does.
Call a professional. For
Yeah,
sure.
please.
For sure.
Yeah. People want more
Okay.
information. How do they get a hold of you?
Yeah, our number is 863-9455. That's 863-WILL. You can find us at willworshamlaw.com or email us here at the station, wworsham@color10.com.
Thank
Oh,
you.
I get it. Make a will.
Make a will.
That's
For
so
there's a
clever.
will, there's a way.
All right.
We'll be right back.